My name is, we'll be recording the meeting today. My name is Christina Postolowski. I'm the program manager for the Mobile Home Park Oversight Program in the Department of Local Affairs, Division of Housing. We're going to be talking today about filing a complaint with our oversight program if you are part of a local government or a nonprofit organization. Before I get too far into the presentation, I'm going to turn it over to our Spanish language interpreter, Yasmin, for an introduction.
Thank you so much. Good morning, everyone. My name is Jasmine. I'm here on behalf of the CLC. I'm here as a part of your commitment to practicing language justice. So we'll be facilitating interpretation simultaneously into Spanish. So I ask that everyone who is not fully bilingual in English and Spanish, please go ahead and select your preferred language. Once we finish these instructions, we'll turn on that function. At that point, you will see a globe pop up at the bottom of your screen. It'll say interpretation. From there, you can select the language that you would like to listen to this meeting in. If you're joining us from a cell phone or another mobile device, you can find this option on the menu with the three dots that says more. Either way, it's the same. Again, if you're not bilingual in English and Spanish, go ahead and select your preferred language. I ask that y'all just keep in mind your pace and your clarity. Try to take your time with your words. And if at any point you're having issues with the audio, you can send a message via the chat and I'll be happy to support that way. I'm going to repeat this in Spanish now. Hola, buenos días. Mi nombre es Yasmín. Estoy aquí de parte de la CLC. Estoy aquí para facilitar el compromiso que ustedes han hecho con la justicia del lenguaje. Queremos facilitar este espacio para que todos puedan participar en el idioma de su corazón y vamos a facilitar la interpretación simultánea para esta reunión. En cuanto termine de dar estas instrucciones, vamos a encender esa función y en ese momento, si no son completamente bilingües en inglés y en español, les vamos a pedir que elijan su idioma preferido de participación. Va a haber en la parte inferior de su pantalla un globo que dice interpretación, o si nos acompaña desde una tableta o algún aparato móvil, nos puede hacer clic en el botón con los tres puntitos que dice more o que dice más. De cualquier forma es lo mismo, dice interpretación y ahí se selecciona el idioma preferido. Les pido que tengan en mente su velocidad y su claridad y cualquier cosa que se les ofrezca me pueden mandar un mensaje por el chat y ahí con mucho gusto les ayudo. Muchísimas gracias, ya podemos comenzar. Okay, thank you all so much. We can go ahead and start interpretation.
Thank you, Jasmine. So as I mentioned at the start, this meeting will be recorded. It will be available on our website after the presentation if you have colleagues who perhaps are interested and were not able to attend today. We will also be posting the Spanish language interpretation for the presentation for anyone who needs access to it in Spanish. So we're going to talk today about some of the state laws governing mobile home parks in Colorado, the main one being the Mobile Home Park Act. We're going to talk about what we do at the Division of Housing through the Mobile Home Park Oversight Program. We're going to talk about filing a complaint with the program. The main purpose or impetus for this webinar today is that as of July 1st, 2024, nonprofit organizations and local governments can file complaints directly with the division. And we'll talk a little bit more about the requirements around that in the presentation. We'll go through a general overview of what our investigation process looks like when we receive a complaint, what some potential outcomes or results of filing a complaint might be, and then we'll have some time for questions and comments. We are looking to do additional presentations for local government and nonprofit stakeholders in the future as well. So if there's something that I don't cover today that you think would be really helpful to you or your organization, please let us know at the end of the presentation and we can look at setting up a future training on the topic. So the Mobile Home Park Act is the main state statute that governs the relationship between landlords and tenant homeowners in mobile home parks. Parts of the act have been in our state law since the 1970s, but there was historically a low awareness of this law, and there was no state agency tasked with enforcing the law. So in 2018, the Department of Regulatory Agencies, or DORA, not to be confused with the Department of Local Affairs, or DOLA, was asked to conduct a sunrise review of the Mobile Home Park Act. So looking at what conditions were like in mobile home parks, particularly with a focus on what conditions were like for resident homeowners, and how the act was or wasn't being followed or implemented. So this sunrise review identified that harm was occurring in mobile home parks, largely due to a lack of awareness and enforcement of the existing laws in our state. One of the questions that was asked in the sunrise review is whether mobile home park owners and managers should be licensed. Licensure was not recommended, but there was a recommendation made around enforcing existing laws. That led in 2019 to House Bill 19-1309, which went into effect May 23rd of that year. And that created an oversight program for mobile home parks in the Division of Housing. Excuse me. And that is, of course, the program that we're going to be talking about today. So the Mobile Home Park Oversight Program, we go by the acronym MPOP, MHPOP. We have several different duties under state law. While we don't license mobile home park owners or managers in Colorado, mobile home parks are required to register with the Division of Housing each year. And we'll talk a little bit more about the registration requirements in a few slides. Our program is tasked with resolving disputes that are submitted through our complaint program between landlords and homeowners. Now, one of the main reasons there is this special law in Colorado on mobile home parks is because of the unique landlord-tenant relationship that exists in mobile home parks. So in a mobile home park, individuals own the home that they live in, but they don't own the land underneath it. That is owned by a separate party. So there is sort of split responsibilities for different things, the home versus the land and utilities and roads in the community. Also, this idea of mobile homes being mobile is a misnomer. It is very difficult or costly to move many mobile homes. So an individual who's buying a home in a mobile home park is more or less stuck there with their investment. So if the landlord-tenant relationship goes awry, if homeowners' rights are being violated, that can put homeowners in a really difficult position of either staying under less than ideal circumstances or leaving but losing their investment in their home. So that's why there is a special law and program for mobile homeowners in mobile home parks. So in addition to registration and complaint resolution, we're tasked with educating parties about state law. We can issue notices of violation if we investigate a complaint and find that a violation of the law has occurred. We'll talk a little bit more about what those look like or can require later on in the presentation. We also engage in public rulemaking to implement and clarify state law. And we work with an independent contractor to conduct a statewide survey each year related to mobile home parks and produce an annual report. If you have questions or comments throughout the presentation, I forgot to mention, please feel free to put questions and comments in the chat as they come up, and we'll respond to those. So I wanted to start with a definition of a mobile home. So in state law in Colorado, mobile homes have 6 characteristics. They're a single family dwelling. They're built on a permanent chassis. They're designed for long-term residential occupancy. And the key here is the design of the building, not how they're being used. So we know that unfortunately, there are many individuals in our state who are living in recreational vehicles or other homes that are not designed for long-term residential occupancy year-round. Even if someone's living in a home year-round, it doesn't make it a mobile home. Under state law, what is key is whether the home was designed to be lived in year-round. Mobile homes also contain complete electrical, plumbing, and sanitary facilities in the home. They're designed to be installed in a permanent or semi-permanent manner, and they can have a permanent foundation or not have a permanent foundation. And then they have to be able to be drawn over public highways, at least when they are installed. So mobile homes, this definition includes manufactured homes, which are also sometimes called HUD homes. So these are homes built to the federal government standards after 1976. Also includes pre-1976 mobile homes. Includes modular homes, which are factory-built structures. If those homes have all of the characteristics of a mobile home and they're located in a mobile home park. Mobile homes include a limited set of tiny homes. So in 2023, the state developed standards for the construction of tiny homes. Any tiny homes built to those state standards are considered a mobile home. Many tiny homes in our state were built prior to the adoption of these standards, and most of those would not be considered mobile homes. So there are some park model homes or park model RVs or pre-2023 tiny homes that may be considered mobile homes, but only if they have all the characteristics of a mobile home that we went over in the last slide. So mobile homes do not include, under our state program and the Mobile Home Park Act, campers, camper trailers, fifth wheel trailers, RVs, motorhomes, travel trailers, truck campers. And most park model homes and most tiny homes are also not going to be in our program. We often get questions about whether RVs or RV parks are covered in our program. So that's why I'm going over some of these definitions here at the beginning of our presentation. So mobile home park. In Colorado, a mobile home park is a community that has 5 or more mobile homes. So if you are in an area and there are communities that have 4 mobile homes, 2 mobile homes, those are not going to fall under our program or the state's mobile home park laws. 5 or more is the threshold here in Colorado. And specifically, it's 5 or more homes for which the owner or the management of the community has a rental agreement for the home itself or the home and the lot. Or sorry, excuse me, for the home and the lot or just the lot. Or where the management or owner is receiving rent payments for the home and lot or just the lot. So a community is considered a mobile home park even if it doesn't have any tenant homeowners. So if the landlord owns all of the homes in a park and rents them out, it's still considered a mobile home park if there are 5 or more. So most RV parks in the state are not going to be included in our program or under the Mobile Home Park Act. However, if it is a mixed use community, so there's an RV park that has 5 or more mobile homes, it will be a mobile home park under our program and be required to register each year with the state. So a little bit more about park registration. So mobile home parks are required to register with the Division of Housing on an annual basis. Each park will have a registration expiration date assigned after their registration is reviewed and approved by staff, and they'll need to submit a new registration each year before that expiration date. Most mobile home parks have an expiration date in February or March of each year, but there are some that have different expiration dates depending on when they submitted a previous registration. There is a registration fee, and the registration fees are the main way that the Oversight program is funded. So the fee is required for each tenant-owned home in a park, and the landlord can, but is not required to, pass on up to half of the fee to tenant homeowners. So the current registration fee is $24 for each tenant-owned home in the park, and the landlord can pass on up to $12 of that to the tenant, or $1 a month, and then the landlord is responsible for paying the other $12 for the year for that home. There is a penalty for late registration, and the landlord is prohibited from increasing rent in the mobile home park if they do not have an active registration with the Division of Housing. So a little bit more on the information that we collect through the registration process. We often get questions from nonprofits or local governments about contact information or other information on mobile home parks. So here's the type of information that we have in our database and that can be requested from the Division of Housing. So we'll have the park name, any doing business as names, the address and contact information for the park. Landlords have to submit the names and contact information for the ownership and management, either individuals or companies that own and manage the park. We also collect information on any controlling entities. So if there is, for example, a parent company that owns or manages the park, that is submitted through the registration process to the division. As of last year, so 2023, we collect information on the park's water source or sources, as well as how the park bills residents for water and sewer. Landlords are required to submit information on how many lots they have in the park and how each lot is used. So whether it's for a mobile home, a tenant-owned home, or a home that they're renting out, whether there's an RV on the lot, or it's used for another purpose. The mailing address of each homeowner in the community, although we do not collect homeowner names, and the date and amount of the most recent rent increase for each lot in the park, lot or home in the park. We do not have information on the total lot rent, only the amount that rent was last increased and the date of that increase. So we wouldn't know, for example, if rent was $800 or $1,000 a month. we would just see, okay, it was a $50 increase, this January. Starting June 30th, 2024, landlords have to identify whether they have a rent-to-own agreement for a particular home that was entered into on or after June 30th of this year. So where can you find this data? We have several resources on our website that have information on registered mobile home parks. So we have a searchable database of registered parks. You can search for parks by city or county specifically. When you go to this search page, you'll see the owner and manager business names. However, we don't have contact information or individual names posted on our website. That can be requested separately from the program. You'll also be able to click on a mobile home park name and view any closed complaints against the park. And there'll be a note about how the complaint was closed and then generally what the issue was in the complaint. We don't have information on complaints that are open and still under investigation on the website. Oh, apologies, one correction. We do have individual owner and manager names on the website. We just don't have the contact information. That would be something that you could request through the program. We also have a list of mobile home parks that are likely prohibited from increasing rent, and this list is sorted by county and then city. So if you are working with individuals from a particular community who say got a notice of a rent increase, you can check this list on our website to see if that park is allowed to increase rent or not. So parks that are not allowed to increase rent or issue a notice of rent increase would be parks that don't have an active registration with us. So they've either never registered or they have not, more likely they have not renewed their registration. If a park has unpaid penalties owed to the Division of Housing, they are also not permitted to increase rent while they have those penalties outstanding. And then new this year, if a park is not in compliance with any federal, state, or local government order, so this includes administrative orders or court orders, they're not allowed to issue a notice of rent increase or to increase rent. So for those of you who are joining us today from a local government, or are aware of federal, state, or local court orders against a mobile home park, those can be reported to our program and we can communicate with the park about this new provision that prohibits them from increasing rent. So it's just the existence of a court order or an administrative order, like a violation notice from a local government, a code compliance notice, that doesn't automatically stop a park from increasing rent. But if a park is not in compliance with that, they haven't taken the actions they need to take to fix the issue or haven't paid any outstanding penalties, the park would be prohibited from increasing rent until they're in compliance with those orders. So again, please, if you are aware of outstanding, say, code violations against a mobile home park or other orders, and you would like the park to be notified that they're prohibited from increasing rent, please contact us and let us know about those outstanding orders. We also have a list on our website of mobile home parks that are owned by nonprofits, local governments, or homeowner cooperatives. And this list is also sorted by county and then city. So if you are working with a group of homeowners on potentially making an offer to buy a park, if you're a local government that's considering making an offer to purchase a mobile home park and preserve it as affordable housing, and you want to know what other communities or nonprofits or local governments in the state have done this, you can refer to this list here um, and reach out to others who may have gone through a similar process. And for those of you who are joining us by computer or on the mobile app, we have been posting links in the chat to these different resources, in addition to the hyperlinks in the presentation, which you can't click on now, but will be able to access afterwards. So a little bit more on other data that we have. So if there is information that we collect through the registration process that isn't posted on our website, you can make an open records request with the Department of Local Affairs for that information, and we will work on providing that for you. So information that's available by open records request currently would be information on mobile home parks that may be for sale, contact information for the owner and or manager of a mobile home park. This includes mailing addresses, phone numbers, email addresses, a list of homeowner mailing addresses by park or city or county. This will not include any names. The number of lots and homes in each mobile home park, the date and amount of the most recent rent increase, water source, water or sewer billing information. One thing I will mention, we do not collect information on RV parks if they don't have the 5 or more mobile homes. So RV parks that aren't mobile home parks, we don't collect information on those. We don't collect information on mobile homes that are located outside of a mobile home park. So mobile homes that are on someone's individual property or that are in a mobile home subdivision where the homeowners also own the individual land beneath the home. The state demography office may have some information on those numbers, so RVs or mobile homes generally in the state through the US Census. So if you're looking for information on mobile homes that aren't in mobile home parks, the state demography office might be a place to go for that. So what is in the Mobile Home Park Act? The Act primarily talks about protections for individuals who own their homes but rent land from someone else. There are also more limited rights that are enumerated in the Act or listed in the Act for individuals who are renting a home in a mobile home park and for the owners and managers of mobile home parks. But the Act is primarily to protect homeowners who've made an investment in a home that is not easy to move. So generally speaking, in the Act, there are guidelines for rental agreements, new leases, how landlords can charge residents for water, for parameters around rent increases, and then what types of rules and regulations a mobile home park landlord can adopt and enforce against homeowners. There are also limitations on the reasons that a landlord can end a homeowner's tenancy. So it is more difficult, legally speaking, for a landlord to end the tenancy of someone who owns their home than for a landlord to end the tenancy of someone who rents their home or rents an apartment or other type of dwelling unit. This is a big one. There is a list of maintenance responsibilities for landlords. So things in the mobile home park that the landlord is responsible for maintaining and repairing under state law. There is a list of responsibilities that may apply to landlords during water or other utility service disruptions. If that water service disruption or utility service disruption is due to the landlord's failure to maintain or repair water lines or utility lines that they own in the park. There is a requirement around compensation for homeowners if a landlord decides to close or redevelop part or all of a mobile home park. And that closure or redevelopment would result in the displacement or eviction of mobile homes. There is also an opportunity to purchase law for homeowners if the mobile home park goes up for sale, and a public entity right of first refusal to buy the park if the homeowners choose to assign their opportunity to purchase to a public entity, and that public entity is going to buy the park to preserve it as long-term affordable housing. Apologies, my slides have frozen here. There we go. So a little bit more about leases for homeowners in mobile home parks. A signed written rental agreement is required in mobile home parks under the Mobile Home Park Act. So the landlord is required to offer a written agreement to a homeowner after they apply for tenancy, and both parties are required to sign that agreement. Homeowners can make a written request for a lease of 1 year or more after their initial lease term if they are current on their rent payments. Or they can choose to stay on the initial lease that they sign on a month-to-month basis for the entire time that they are a tenant in the mobile home park. So this is a unique feature of tenancy in mobile home parks. Homeowners who are renting lot space do not have to sign a new lease or renew their lease each year. They can stay on their initial lease until they choose to end the lease or the landlord has a reason to terminate their tenancy that is specified in the State Mobile Home Park Act. In 2022, language was also added to the Mobile Home Park Act that makes it a violation for a landlord to require a homeowner to sign a new lease or mislead a homeowner about signing a new lease. This is still an area of confusion for some landlords and homeowners. So for example, we will hear from homeowners, the landlord hasn't given me a new lease. I only have this lease from 2014 that I signed. Well, that lease is still their lease. and is still an active lease, provided that they haven't signed a different agreement with the landlord and the landlord hasn't, or the homeowner hasn't ended the tenancy. Some of the maintenance responsibilities that landlords have in mobile home parks are to maintain premises that are safe, clean, and accessible to people with disabilities. So some basic requirements about the property being habitable to the individuals who live there. Landlords are responsible for maintaining water, sewer, and utility lines and related connections that are owned and provided by the landlord to the utility pedestal or pad space for the mobile home. This is often something that comes up in the complaints that we receive, and we often get questions around where the landlord's responsibility starts and ends and where the homeowner's responsibility starts and ends. So even if, and I'll also share that even if the local government doesn't have enforcement authority over the landlord's maintenance of the property or things like roads or water lines in the park, under state law, the landlord is required to maintain the premises of the mobile home park. So landlord also has to maintain common areas, ensure they're accessible to people with disabilities, required to maintain roads and other pavement in the park, including snow removal. Landlords are responsible for lot grading and regrading lots underneath mobile homes to ensure that there is adequate drainage and to prevent the pooling of water that would cause damage to the foundation of a mobile home or to the utility pedestal or pad space. Landlords are also required for doing major tree maintenance to protect the safety of residents and their property, and for preserving healthy, mature trees that homeowners reasonably expected to remain in the park. Landlords may have certain responsibilities for water and utility outages in the mobile home park. So landlord is responsible for ensuring that homeowners have and residents have running water and reasonable amounts of water at all times. Now, there is a list of exceptions in the Act to this. So, for example, if an outside utility shuts off the water, the landlord is not in violation of the Act. Landlords are also allowed to shut off water for maintenance and repairs for a limited period of time and with prior notice to residents or in cases of emergency. However, if a landlord fails to maintain water, sewer, or other utility lines, the landlord may have several different responsibilities under the Act. The landlord may be responsible for paying the cost of repairing any damage to a home or lot that results if the landlord failed to maintain a water, sewer, or utility line. If the water goes out due to a landlord's failure to maintain or repair water lines or related connections, the landlord is responsible for providing alternative sources of potable water or water safe for human consumption and maintaining portable toilets for the residents to use during the water service disruption. And we're currently having rulemaking discussions around the amount of water and the number of toilets that landlords may be required to provide in these types of situations. Landlords may also be required to reimburse residents, homeowners and renters for any damages to their persons or property, loss of use of their property, and expenses that they reasonably occur if the landlord has failed to maintain water, sewer, or utility lines that the landlord owns in the park. A little bit more about water and wastewater issues and complaints. So, the Department of Local Affairs, where the Division of Housing and the Mobile Home Park Oversight Program is housed, has jurisdiction over some types of water or wastewater complaints in mobile home parks. Another state agency, Colorado Department of Public Health and Environment, or CDPHE, has jurisdiction over other types of issues that may arise in a mobile home park. So if you're working with a resident, or if you are, as a nonprofit or local government, reporting an issue, we have some more information posted on our website about water and wastewater in mobile home parks. Kind of a quick and dirty shorthand here is that if there is a water outage or a water service disruption, that could be reported to the Mobile Home Park Oversight Program and Colorado Department of Public Health and Environment. We may both have jurisdiction over that issue, over investigating and trying to resolve it. There is a hotline that CDPHE has for reporting water outages, sewage spills. It's an emergency phone number that is posted on their website, and I believe is also on our water and wastewater page. That can be used for specifically emergencies in mobile home parks. If there is an issue related to water quality, those are generally going to be handled by or referred to the Colorado Department of Public Health and Environment. So there was a bill that was passed by the state legislature last year in 2023 that created a statewide water testing program for water quality and safety in mobile home parks. That program just launched July 1st of this year. And so any water quality issues or concerns, taste, color, odor, those are best reported to CDPHE. If there is a sewage spill, an above ground sewage spill in a mobile home park, that can be reported to the Mobile Home Park Oversight Program and or CDPHE. If it is a active and ongoing spill, folks should call CDPHE's emergency line to report that. If the issue has to do with cleanup of a previous spill that is no longer active, that may be better handled through reporting or a complaint to the Mobile Home Park Oversight Program. Finally, sewage releases from mobile home parks to public waterways or neighboring properties are going to be best handled by CDPHE. The Mobile Home Park Oversight Program only has jurisdiction of the mobile home park premises. We don't have jurisdiction over how a mobile home park, either the landlords or homeowners, are affecting neighbors or neighboring properties. Sewage discharge into public waterways or neighboring properties are a public health issue, and so that's why it's going to go under the Department of Public Health and Environment. A little bit on mobile home park sales. So if a landlord intends to sell a mobile home park, the landlord has to provide notice of their intent to sell the park to the homeowners, any residents with an email address, the Department of Local Affairs, so the Mobile Home Park Oversight Program, and the municipality or county where the mobile home park is located. So if the mobile home park is within city limits, within a municipality, the notice would go to the municipality. If they're in an unincorporated part of the county, the notice would go to the county. We often get questions from park owners about where to send the notice. If you're joining us from a local government and have a particular agency in your local government that you would like to receive these notices, please let us know and we can help direct landlords to send the notices to the right place. Otherwise, we're instructing landlords to contact the local government itself and ask, or send it to the city or county clerk and recorder. We do get questions from local governments that get a notice about what it is and why they're getting it. They're getting it because it is a statutory requirement. Some local governments are interested in knowing when mobile home parks are up for sale. Some may not be, but that is why it is being sent to cities and counties. It's a requirement in statute. After each of these notices, a group or association of homeowners, if they have approval of more than half of the homeowners in the park, 51%, they have a 120-day opportunity to make an offer to buy the park. So let me clarify that a little bit. Homeowners have 120 days after each of these notices to decide whether they want to form a group and make an offer to purchase a park. If they do want to make an offer to purchase a park, they're going to need approval of 51% of homeowners in the park to move forward with an offer, to have some of the rights that are in the Mobile Home Park Act around the opportunity to purchase a park. Homeowners who've taken a vote to make an offer to purchase their park can decide to assign their opportunity to buy the park to a nonprofit or a public entity. Public entities include local government agencies, state agencies, and as well as most housing authorities. The landlord who is selling the park is required to negotiate in good faith with the group or association of homeowners that's making an offer to buy the park or their assignees. And then specifically, if homeowners have assigned their opportunity to purchase to a public entity, that public entity has a right of first refusal to buy the park. So if homeowners assign their opportunity to purchase to, for example, a local government, enter into an assignment contract, and then the local government notifies the landlord that they've been assigned the right to purchase the park, the landlord is required to sell to the local government or other public entity. So we've gone over some of the rights and responsibilities in the Mobile Home Park Act that you might come across as a nonprofit or local government working with landlords, homeowners, or residents. Now we're going to talk a little bit more about filing a complaint with our program. So An individual or group that files a complaint with our program has to have an injury or be aggrieved in some way in order for us to investigate the complaint. So someone's rights have to have been violated for us to have jurisdiction over the complaint. If you'll remember, I mentioned when we introduced the Mobile Home Park Act that most of the rights in the Mobile Home Park Act belong to homeowners who are renting lot space. So in general, even though local governments and nonprofits can file complaints, a homeowner is still going to need to be involved in the process with us for us to have jurisdiction. But there are a couple different ways that local governments and nonprofits can report issues to us, can help homeowners and residents file complaints and through the dispute resolution process. And we're going to go over that here in the next couple of slides. But essentially, if to be the main party in a complaint to our program, you have to have suffered an injury. Now, there are different ways that nonprofits and local governments can make complaints to the division. The first is reporting an issue, helping file a complaint, so helping someone file a complaint, acting as an agent for a homeowner or resident, and then filing a complaint as the local government or nonprofit itself. So to report an issue to the division, you can contact us by email or phone. The Division of Housing does have the authority to open our own investigations into issues. So if a nonprofit or local government is communicating with residents or has observed a potential violation of state law, you can contact us and request that we open a complaint. If you are going this route, we are going to strongly recommend and we are going to request supporting documentation and information. The program has over 300 open complaints, and we have generally had that each year. We get about 200 to 300 new complaints each year. So we are going to exercise discretion over whether to open investigation and what issues to investigate. The more information that you can help provide up front to demonstrate there may be a violation of the act or additional investigation is warranted, the more likely it is that we'll be able to pursue an investigation or reach out to the other party for more information. In determining whether to open an investigation or what issues to investigate once an investigation is opened, we will look at several factors, including what is the issue that is being reported, how many people does it impact, how severe is it. We'll look at our other caseload, so individuals and entities that have filed complaints and requested the assistance of the program that way. And we'll also look at how easy or difficult it is going to be to gather evidence and investigate a complaint. So just as an example, if we got an email saying there was a water outage at this mobile home park and the landlord didn't provide alternative drinking water, that by itself is probably not enough information for us to investigate. We would at least need a time frame. When did this happen? And then it would be helpful if there was additional information around do you know the cause of the outage? How long did it last? Did residents ask for reimbursement of any expenses, things like that? And generally, in the past, we've had nonprofits and local governments contact us to raise issues. Y'all have been providing great information for us to launch an investigation or inquiry into the issues. But yeah, the more information that you can provide up front, whether that's with a formal complaint or not, the more quickly we will potentially be able to look into an issue. So beyond reporting an issue, you can also help another party file a complaint. So under this scenario, someone from a local government or nonprofit would help a resident, a homeowner, a homeowners association, or a landlord file a complaint with us, but you wouldn't necessarily be involved in the investigation or the discussions around resolution of the complaint. However, this can still be very beneficial. You as a nonprofit or local government might have the ability to help residents scan and send documentation to the program, put together a group complaint if there are several residents or homeowners facing the same issue. And that will assist them with filing a complaint and assist the division with the investigation process. Another option, if a nonprofit or local government wants to be more involved, or the homeowners or residents or other complainants want the local government or nonprofit to be more involved in the investigation and resolution process, is that you can act as an agent for the person or the group making a complaint. So this would require some type of express permission from the underlying complainant to make the complaint and communicate with the program on their behalf and potentially make certain decisions or communicate certain decisions about the resolution of the case. We have seen this most often in situations where there is a group of homeowners who have a similar issue, and the nonprofit or local government agency is stepping in to help coordinate with that group and communicate with the residents and the program. Nonprofits and local governments can also file their own complaint. And so this was new as of July 1st, 2024. However, local governments and nonprofits have limited rights under the Act. So there are going to be limited circumstances where we'll be able to investigate a complaint from a local government or nonprofit without any resident, homeowner, or landlord also involved. So specifically, we can investigate allegations that a landlord didn't provide a required notice of a park sale or change in use to the local government, that a landlord who's selling a park is not negotiating in good faith with a nonprofit or public entity, that the homeowners have asked to purchase the park on their behalf. We can investigate allegations the landlord is not honoring a public entity's right of first refusal to buy the park, or did not provide an affidavit of compliance following a park sale. So similar to how a landlord is required to provide notice of their intent to sell a park to the municipality or county where the park is located, There is an affidavit form that's required after a park is sold if the buyer is not a group or association of homeowners, and a copy of that form needs to go to the municipality or county as well. So most of the direct complaints that we'll be able to investigate from nonprofits or local governments are going to be related to park sales or changes in use. And a change in use would be a closure or a redevelopment of a park. I will note in terms of filing a complaint on behalf of another party, there is a requirement in state law that the Division of Housing keep the identity of residents and homeowners confidential in certain types of complaints. So that would be confidential from the landlord the complaint is against, and confidential from the public or not subject to public disclosure. So if the complaint is of a general nature, affecting multiple people in the park, and if we can investigate the complaint without disclosing residents or homeowners' identities, we're required to do so. And this would include keeping those identities confidential, even if we got a Colorado Open Records Colorado Open Records Act request or CORA request for the information after the complaint was closed. This confidentiality requirement does not mean that people can file anonymous complaints. So we at the division will typically need contact information and a name of somebody impacted by the alleged violation in order to investigate the complaint. But if the complaint is of a general nature and we can adequately investigate it without disclosing anyone's names, we're required to do so. It's a little bit on how to file a complaint. We have an online complaint form. Individuals can also request a paper complaint form be mailed to them by the division. The complaint form will ask for a written narrative of the issues involved in the complaint. What happened? When did it happen? Who was involved? If there's supporting documents or pictures or videos, they can be uploaded with the complaint form online or emailed or mailed to the program after the complaint is filed. Individuals or groups filing complaints do not have to identify specific provisions of the law they believe have been violated. Our program staff will go through and do that after the complaint is received. However, we can only investigate issues that fall under the Mobile Home Park Act, the Dispute Resolution Program, or our administrative rules and regulations. So if there are issues that don't fall under our program, we will decline to investigate those particular issues. So it may be worth reviewing information on our website about the types of issues that are covered by our program, or reading through the Mobile Home Park Act before filing a complaint to see if the issue might fall under our jurisdiction. You can also contact us and talk to one of our staff to get a sense of whether the issues fall under the Division of Housing or might be better investigated by another state agency, or with the help of an outside attorney. So what happens after you file a complaint? We have a automated confirmation email that will go out if a complaint is filed online and an individual provides an email address. If we get a paper form, we'll also send this confirmation letter by post mail. Great question here in the chat. Can complaints be filed that may fall under Colorado Department of Public Health and Environment, or will they just be closed as not in your wheelhouse? So it depends. If the issues in the complaint are related to some of those issues that are specifically discussed in the Mobile Home Park Act, like water service disruption or a sewage spill in the park, those are complaints that we would investigate through our program. And we may also consult with CDPHE or let them know about the issue. If it is specifically about water quality, right now those issues are being referred directly to CDPHE and then closed under our program. So the complaint can come to us or can go to CDPHE directly, but if it is something that is not in our jurisdiction to investigate, we may communicate that with you and let you know where the complaint was referred or where you might want to file a complaint. Things like wastewater treatment, that would be another issue that would likely need to go directly to CAPHE. You could file it with us, but then we would close that and refer it to them. We are going to prioritize the investigation of complaints that have time-sensitive issues, so things like water outages, electrical outages, or potential evictions. Would also add park sales to this list because that is those sales are potentially on a clock. The homeowners only have 120 days to make that offer to purchase the park. We provide automated status updates on complaints every 2 months. Those are generated by our Salesforce database and will go out through email if you provide an email address, or through post mail if you have not provided an email address to the program. We'll look at whether the complaint falls under the Act, the program, or our administrative rules. And then we'll start a written conversation. Most of our investigation is conducted in writing between the parties. So this may be in email or post mail, depending on what the parties have access to. We may also conduct phone calls with the parties, but generally the investigation is going to be in writing, and any discussions around resolving the complaint will also be done through written communications, as opposed to, a week-long in-person mediation. Another great question. In the case of a resident-owned community, who is considered to be the landlord under the Act? Would it be the homeowner cooperative or the management company? So we are in the process of clarifying this through our rulemaking. There may be multiple landlords in a community. So for example, if there is an LLC or limited liability company that owns the park and a separate business entity that manages the park, those are both landlords. And a complaint could be filed against either entity. Ultimately, though, the owner is responsible for the individual or entity that it hires to manage the park. So in some co-ops, we may not be able to investigate complaints where the co-op is complaining against the management company, because that's essentially a landlord complaint, as opposed to a landlord homeowner or homeowner landlord complaint. But we are working on clarifying this through our rulemaking discussions. After we get initial information from a complainant, we will reach out and ask for a response from the person the complaint is against. Typically, before we're going to send a subpoena to the person a complaint is against or other request for information, we're going to get clarifying information and evidence from the person who filed the complaint. So the more of that you are able to provide upfront, the more quickly we can get to reaching out to the other party or potentially issuing a subpoena for information in the case. After we have information from both parties, if it appears that there is a violation or violations of the act or program, we may start discussions about potential resolutions. Note that the division is not required to hold settlement discussions or give parties the opportunity to reach an agreement. We have some discretion over whether to hold those discussions or whether to move to a determination in a particular case. Certainly, if you as a party to a complaint, if you have specific requests, ideas for resolution, we would love that feedback. But just know, depending on the issues involved and what each individual party wants to do, their willingness to have discussions, the likelihood of reaching a resolution, that will all impact whether we're having settlement discussions or we are looking at just moving to a written determination in the case. For example, if it appears there is no violation of the law, there's not going to be a settlement discussion around that. There would just be a determination that there's not a violation. So if there is a violation, what are our potential remedies? What can the program do? So first, there are some specific penalties that we can assess under the Mobile Home Park Act and the Dispute Resolution and Enforcement Program. Note that the penalties the program can assess are somewhat limited. So we can assess penalties, for example, if a landlord does not timely register their park or renew their park's registration, if a landlord fails to post a required notice that the Division of Housing publishes that spells out homeowner rights and responsibilities. If a landlord fails to post that in the park or share that with residents, there's a penalty associated with that. If a party fails to respond to a subpoena that we issue in the course of an investigation, there are penalties associated with that. If a landlord retaliates against a homeowner or resident who has filed a complaint with our program or with another government agency, there may be a penalty associated with that. And then if a landlord has failed to comply with any final agency order that we issue through a complaint process, there are daily penalties associated with that failure to comply. Generally, the program does not have the authority to issue punitive penalties. So if a resident or homeowner or local government or nonprofit is seeking a large penalty against a mobile home park as punishment for a violation of the act, that remedy should probably be pursued through a complaint in civil court. Homeowners and residents have a private right of action to file complaints in court against mobile home park landlords. And there are some specific remedies spelled out in the act if a homeowner or resident goes that route. So, sometimes folks come to us and say, I really want you to make this landlord pay. I want a huge penalty for the violation of the act. That is generally not the purpose of our program. While there are some penalties that are specified that we can assess, our main actions or remedies are going to be to try to get the landlord or resident to fix the violations. So we can spell out specific actions that a landlord or homeowner or resident are required to take, or excuse me, landlord or homeowner are required to take to cure a violation of state law. Landlords specifically may be required to reduce rent, prorate rent, issue reimbursements, or provide compensation to homeowners as a way to correct violations of the act. There is also language in the act related to park sales that landlords may be required to potentially reverse a sale of a park or pay a percentage of the sale price to homeowners if they don't give homeowners the opportunity to purchase the park. And there are some different enforcement mechanisms for the opportunity to purchase requirements. Some of that is through the Mobile Home Park Oversight Program, the Attorney General's Office, or civil court are other options for enforcing the park sale laws in Colorado. One remedy I'll also highlight is the program has the ability to issue cease and desist orders. So our cease and desist orders require the party the order is against to cease violations of the act or program within 48 hours. If a party does not stop violating the act or program within that time frame, the Division of Housing can go to civil court and request a temporary restraining order or an injunction against the landlord or homeowner to stop the violations of the act. The cease and desist orders that our program has issued so far have primarily dealt with water issues, so water service disruptions, sewage spills, or electrical service disruptions, or health and safety issues related to things like electricity, natural gas, sewer, and water in parks. So that's one category related to the landlord maintenance responsibilities. Another category would be park sales. So if a landlord is potentially moving forward with a sale without giving homeowners the opportunity to purchase, we might issue a cease and desist order to prevent immediate harm in that case. Or I'd say the third category where we have typically issued cease and desist orders is around um, tenancy terminations or evictions. So there has to be a likely violation of the act that has occurred or will soon be occurring, and immediate enforcement needs to be necessary in order for us to issue that cease and desist order. So what are some other potential results at the end of the complaint process? So a complaint may be resolved by issuing or entering into a settlement agreement, all the parties entering into a settlement agreement that is then signed off on by the Division of Housing. The division may issue a notice of violation or notice of non-violation, or both in a particular complaint. If the division issues a notice of violation or notice of non-violation, either party has an opportunity to appeal. They have 15 business days to request an appeal and a hearing with the Office of Administrative Courts. If no one requests a hearing, the notice of violation or non-violation will become a final agency order. Or if after a hearing, or if there is a hearing and the judge enters an order, that will become a final agency order. And then the parties have to comply with what is in that final order. There are penalties that can be assessed if a party does not comply with the final agency order, and any penalties that are assessed against a landlord are a lien against the mobile home park, so a lien against the property. So we'll now open it up for questions and comments. Y'all have been a quiet group today, but I hope this information has been helpful, and we'll open it up for questions and comments at this time. I see Daryl or Dariel Monley. We're going to open your line to go ahead and talk.
Can you hear me?
Yes.
Okay. And this may have been explained, but the people across the street from me are having trouble with the management in terms of being able to buy the house next door. And it looks like there's some, like he's trying to prevent that unnecessarily. And I'm wondering if I can help as not as an agent, but as a resident of the park, helping them because they're Hispanic and they don't understand the situation well. And, if I can help them as in filing a complaint.
Yeah, great question. So you would be able to help them file a complaint in terms of filling out a complaint form. Those individuals or any individuals who are having a particular issue would need to be involved in the complaint process or give their consent to, have you file a complaint on their behalf. So we can't investigate complaints of, just say you were to file a complaint for your neighbors and they're not involved in the process at all. We're not able to investigate complaints that way. But if you were able to help them fill out the form, if you want to give them the program's contact information, we do have staff who are fluent in Spanish who might be able to assist them, or talk through the complaint process. So those are ways that you could help out, but the individuals who are impacted would need to be involved in the complaint process.
Yes, I understand that, and I think they understand that as well. But thank you. I just want to see what my part in it might be able to be in helping them. Yeah,
Thank you for the question.
thank you.
So another question in the chat, or request for me to address what is now required for language equity for notices in mobile home parks and recommendations for Know Your Rights trainings. So the state legislature passed a bill this year, House Bill 24-1294, on mobile homes and mobile home parks. A big part of this legislation was language access in terms of the communications that landlords provide to homeowners and residents in mobile home parks. So landlords are now required to provide most communications that they provide to residents in English and Spanish. And residents may also request communications in one other language that they speak beyond English and Spanish. And once that request is made, landlords are required to provide communications to that resident in their requested language. There is also guidelines in the Act now about landlords being required to communicate in a way using language that is easily understood by residents, to provide information verbally upon request, and provide language interpretation at resident meetings and community meetings. So unfortunately, don't have time to go into more detail in this presentation, but we are expecting to put some more information up on our website about the new language requirements. In terms of Know Your Rights trainings, Kathy, can you speak a little bit more about what the question or request is there? I asked to unmute you. Cassie, can you unmute Kathy Smith?
She just chatted.
Okay. So if there are nonprofits, is the question about whether nonprofits can offer trainings or whether there are nonprofits that are offering trainings? I guess I can answer both. There are a couple of nonprofit organizations in Colorado that I believe are offering Know Your Rights trainings for residents and homeowners. Colorado Poverty Law Project, or CPLP, I believe provides some trainings, as well as 9 to 5 Colorado. We do not publish trainings offered by other groups on our website, but we do have a list of some other organizations that we are aware of that work with homeowners or landlords on our website. So recommendation would be to go to the websites of those groups to see what trainings are coming up. You can also request a training from the Division of Housing and the Mobile Home Park Oversight Program, depending on available staff resources. We can potentially provide a training. You can submit that request by sending an email to our program or giving us a call at our toll-free number. Michelle Gouroulet, who is on our call today, is our community outreach liaison, and she can work with you directly to see what your needs are and to set up a training in your community. The legal and rent assistance resources for tenants link that Michelle just added in the chat, and that is available on our website, lists those other organizations that may have trainings available. I see Aaliyah Rodriguez has her hand raised or his hand raised, so I'll open up your line to talk.
Thank you. I was typing some questions and it was long, so I thought since we're kind of a small group, I could just chime in. I work for Larimer County, and I'm just trying to wrap my brain around how our local government could help with filing these complaints. And I have a few questions that might be too specific for you to answer, and that's fine, but I just wanted to throw them out there. I'm really just trying to understand the types of violations and complaints that would rise to the top or that would warrant an investigation, since your office does get so many every year. Like some examples, you talked about general maintenance earlier, that being a responsibility of the park owner. So I understand, trimming trees is one that we've heard often. So that could be something filed. I imagine that would be an easy one to provide photos and dates and documentation for. Another one, within that definition of general maintenance, you talked about safety. So we've heard from a park just recently about, gun violence in the park and the park owner not responding to the violence that's happening in the park, not communicating because it was recently sold. They don't know who to contact about it and what the park owner would even do. Is park safety in that sense of violence something that falls within this act?
So those are great questions. Trees, roads, snow removal, utilities, those would all clearly fall under our program and be something that we could investigate. Gun violence, likely not. So that is likely an issue where we would refer residents to contact local law enforcement. So criminal activity, things like that, would be outside the jurisdiction of our program.
What about the park owners not responding to residents? Like that part, the part that the residents aren't able to get a response or communication from the park owner regarding the violence. Is that something?
So there are some requirements in the Mobile Home Park Act about the landlord having to post and share an emergency number.
Okay.
And having to share their contact information. So where appeals can be made to the landlord. So ownership information, some basic ownership information, contact information, an emergency phone number has to be shared with residents. There is no requirement in the act specifically that landlords respond. Um,
Oh,
so that could present a challenge. And there's no specific requirement that landlords evict someone, and that's typically not something we would be involved in through the program. So again, I think probably local law enforcement is going to be the best resource for that. But if the
okay.
landlord hasn't provided contact information or provided an emergency number, we could investigate that.
Thank you. I just have one more quick one.
Of course.
There's another park in our jurisdiction that's talking about wanting fencing, which comes to our land use code, which is fine. But in order for them to even think about putting fences around their lots, they need to know their lot lines. I'm wondering if there's anything in this around mobile home park owners required to designate the land. So they're having trouble because there's not official lot lines written down like at the clerk and recorder or at the assessor's office. And so is there anything where the park owners have to tell the tenants exactly what their parcel entails?
There is not currently explicit language in the Mobile Home Park Act about the landlord designating lot lines. Under the rental agreement is supposed to disclose the terms and conditions of the tenancy. So this is potentially something that we could investigate if residents feel like a rental agreement doesn't disclose what exactly they're renting. But there's no explicit requirement for the landlord to designate those lot lines. And we have heard from landlords in previous public meetings that sometimes things like lot size may change due to a larger home being moved in next door, or due to adding sidewalks to a park that didn't have them before. So I would say that this is an issue that's come up before, and that the law isn't 100% clear on. So we could potentially look at this through a complaint process.
Okay, thank you.
Darielle, did you have another question? I'll go ahead and unmute you.
Yes, I did. I am wondering, in our park, the landlord says that residents cannot work on their cars, cannot even change a light bulb, cannot change their oil, cannot do any of these things in the park. And I wonder, is that legal for them to prevent the residents from doing this? Because in our park, of course, many of them, the people here are not wealthy enough to be able to take their car to a dealer every time they want to get their oil changed. So I'm wondering whether there's any grounds for a complaint against the park for, such harsh restraints on the part of the residents.
Yes, so there may be grounds for complaint around that. Typically, when we've seen those prohibitions on, working on a car in the park, it's something that's part of the mobile home parks, like rules and regulations.
Mm-hmm.
And the Mobile Home Park Act says that a landlord can only enforce rules and regulations if they are for a certain purpose, which is listed in the Mobile Home Park Act. So that may be something that we could look at through the complaint process. If a landlord is enforcing that rule, or someone is getting a violation notice, for working on a car in the park.
Yeah, and they do. I'm also wondering if, in this park, the rules and regulations over the years, I think different rules and regulations have been handed out to people as they move in the park. And if probably in some of the older rules and regulations, this rule did not apply. This was not a part of it. So in that case, it would seem that that person isn't constrained by those rules. It's not in their rules and regulations. Would that be true?
So we would have to look at the, individual situation and communications. A landlord is allowed to change certain rules and regulations with 60 days written notice to residents. But when it comes to rules and regulations that affect what a homeowner can do with the home itself, the landlord is much more limited in making changes to those after someone moves into a park. So it depends whether the person agreed to the changes or not, whether the residents were properly notified of the changes, and then, whether a landlord can change a rule or regulation for existing residents will also depend on whether the rule has to do with the home or the lot or the premises, if that makes sense.
Yeah. So I would have to look at the actual Mobile Home Park Act to see what sort of if this regulation really was something that a landlord could place on the residents um, in order to determine whether or not we could actually file a complaint against it. That we have to look further into the act.
Yeah. And so the specific section that talks about the types of community rules and regulations that a landlord can enforce is section 38-12-14 of the
38.
Colorado Revised Statutes.
Okay. And it is the Mobile Home Park Act.
Yes.
Mhm. Okay.
And I believe we can add a link as well in the chat to get to the act through our website. And we also have instructions, like an instructional video on our website on how to find certain sections of the statute.
Great. Thank you very much.
Thank you. Well, we are over time, so we're going to go ahead and end the training. I want to thank everyone for joining today. Please follow up with us if you have additional questions or concerns that come to mind, or questions that are specific to your community or your city or county where you're located. Thank you very much. We're just going to stay on the line for a moment to make sure we capture the chat and the recording.
Thank you so much, Christina, for your help today.
No problem. Thank you.